session, and first from the Mohit mineral. So friends, in the case of the Mohit mineral, what was the fact of the case we'll discuss, but what is the issue? Issue is that levy of the GST or is on the ocean freight, whether it's a valid or not. First of all, if we see the overview of the levy of indirect tax, or the, you can say earlier service tax and now GST in case of ocean freight, then before 12/1/2017 means 12 January 2017 के पहले it was exempted under the service tax. So it was covered under notification 25/2012. 25 notification was of mega exemption notification. तो आपने किसी ने अगर सर्विस टैक्स में प्रैक्टिस किया होगा या सर्विस टैक्स लॉ पढ़ा हुआ होगा. So 25/2012 was the mega exemption notification, and the levy of the ocean freight from the outside India to the Indian port, whatever the transportation cost, the levy on that freight will be included or exempted under the exemption under this notification. But on 12/1/2017, that is from the 12th January 2017 till the 30th June 2017, this means this is the pre-GST period before the implementation of the GST. GST is implemented from the 1st July 2017. So for that period, that exemption, which is given by way of notification 25/2012, was withdrawn, and notification 1/2017 has levied the service tax under river charge. तो ये जो पीरियड था 3 आप बोल सकते हैं जनवरी टू जून 2017 का, तब के पीरियड के लिए सर्विस टैक्स लेविड है on the ocean freight, and that is under the RCM. You can refer the notification 1/2017 ST. Afterward, when GST law was introduced on the from the 1st July 2017, it specifically included in the notification 8/2017 read with notification 10/2017 from 1st July 2017 at IGST is payable under river charge. So what is the fact? So just we had taken the review of the legal provision of applicability of the RCM or the GST or service tax under the RCM on the ocean freight. But what was the fact of the case? So what is the fact under the consideration before the apex court? First of all, let's understand the difference between the FOB and CIF. So whenever anyone import the goods or any goods are imported, it can be on FOB basis and on CIF basis. So FOB is free on board. Free on board means where an entity, Indian entity or Indian shipping line incurred the transportation cost from the port outside India to the custom port or Indian custom port. So ये जो transportation or ocean freight है, that will be incurred by the Indian importer, and the value, that is the import of goods का जो value है, उसमें insurance on freight included नहीं रहता है. That is called as FOB based value. And what is CIF based value? CIF means insurance and freight is included. So whenever there is a CIF valuation, import of goods include the insurance and freight also. And freight is incurred by the foreign shipping line, and it is bear by the foreign company or the exporter. So that is CIF. So the decision is with respect to CIF value and not FOB value. So apex court decision is related to the CIF basis, that is the cost, insurance and freight basis where जो valuation होता है during the transportation of the goods, that is based. So what are the fact? So fact of the case क्या था? So the taxpayer is engaged in import of the coal. So taxpayer coal import, he imported coal from various like Indonesia, South Africa, US by ocean transport, and whatever the transport is incurred by the foreign shipping line and by the exporter. So value, import of goods का जो value है, that is cost on the CIF basis. That means value of the goods includes the cost of insurance as well as cost of freight. So the main contention or the main issue was whether the freight which is incurred by the foreign shipping, which is incurred by the foreign shipping line and bear by the foreign export company, whether that freight is liable to IGST under revert charge. So this was the question before the court. Now, the key discussion in the case of this case is decided by the Gujarat High Court first before Apex Court, and Gujarat High Court in front of the Gujarat High Court, the notification 8 by 2017 and notification 10 by 2017 had challenged. So read filed to challenging this notification, that these notifications are not in tune with the GST law, and how it is not in tune with the GST law or not, or override the GST law, we'll discuss. So first of all, we discussed the key legal provisions. So we had understood what was the issue. We had understood what is challenge has made before the Gujarat High Court, and Gujarat High Court has said also from the taxpayer point of view that these notifications are not in tune with or override the GST law. But Apex Court observations are different, and we are today going to discuss only the observations of the Apex Court. So friends, if we see the levy for any transaction, if you have to decide the taxability, or let's say you have to decide the GST, then three are the key important area you require to decide. First, levy, then what is the rate, and third is the valuation. So these notifications, whatever under discussion, 8 by 2017 and 10 by 2017 is for the levy, or you can say rate and valuation. So first of all, let's discuss about the levy. For levy of ocean freight, you require to refer section 5 of the IGST Act. And as per section 5 of the IGST Act, if you refer subsection 3, it says that the government may, on recommendation of the council by notification, specify the categories of the supply. And under subsection 5, it can specify the class of the registered person where recipient is liable to pay the tax. So under these two sections, government has issued a notification 10 by 2017, wherein entry number 10 specify that the ocean freight, that is the services supplied by a person located in non-taxable territory by way of transportation of goods by a vessel from a place outside India up to the custom station of India, up to the clearance of the India, and recipient is the importer. So if you see the definition of importer, importer is the person who is liable to pay the consideration either or who receives the services. Now in case of CIF basis, importer is neither liable to pay the freight. Freight is paid by the exporter. And similar, the recipient of the service is the exporter and not the importer. And hence one can say the notification 10 deemed the importer as a recipient for the ocean freight, which is on the CIF based valuation. So it's created a teeming fiction and liable and made liability on the importer for paying the IGST. Now, if you refer, what is the rate for the ocean freight was discussed. It was discussed in the notification 8 by 2017, and as per notification 8 by 2017, rate for ocean freight prescribed is 5%. So it's a 5%. Now the question arises about the valuation. क्योंकि आप जब import करते हैं on CIF basis, तो complete जो value रहती है that include the ocean freight also. So how we arrive at the valuation? So for that purpose, government has issued a corriendum for notification 8 by 2017 and saying that the 10% of the CIF value is the value for the ocean freight. So these are the legal provision on the basis of which government has levied the tax or the ocean levied the GST on the ocean freight or the IGST freight. So key legal provision. तो आपको legal provision पता चल गए. So first of all, levy is under section 5. Under section 5(3), they had issued a notification 10 by 2017. That is the RCM notification. RCM is levied, and importer is the deemed recipient as per this notification. Then rate is given in the notification 8 by 2017, and both these notifications are challenged in the Apex Court that these notifications are not in tune with the law or GST law. Is not as per the GST law. and value is again by way of notification, by way of corriendum, and that sets at 10%. So we are having a value also, rate also, and levy also. Now, what is the key contention of the taxpayer for the for this case? So first of all, the taxpayer or the respondent has said that the notification 8 by 2017, that is, we had discussed about the rate, and notification 10 by 2017, where importer is said to be deemed a person, are ultra virus to the IGST and CGST Act. Now, why it's ultra virus and what are the contention of the taxpayer? First contention is that the recipient, that is, he is deemed as a recipient. However, recipient is defined under the GST law, and the importer is not the recipient for the ocean freight, but the exporter and the shipping line. That is, the shipping line paying the consideration, and he is not a recipient, and he is the recipient, or the exporter who bear that or who is the recipient of the ocean freight service is the recipient as per the GST law, and hence the deemed recipient is not, cannot be prescribed under the notification 10. This is the contention by the taxpayer. Second contention, if you see taxpayer from the taxpayer perspective, it says that the Section 503 of the IGST Act only delegate the power to identify the categories of the goods and services, and it can't identify the recipient, or you can say the service recipient or importer. So why this contention? If you read again the Section 503, it says that the government, on recommendation of the council by notification, specifies the categories of the supply of the goods or services. So it specifically mentioned that it can specify, or government can specify, only the categories of the supply of the goods or services or both. And accordingly, the taxpayer contention was, under this section, the notification should be issued for the categories of the goods and services and not for the service recipient. So notification 10 by 2017 identifies an importer as a service recipient, and it is not under the power of Section 503, or it cannot be identified under Section 503, and it's ultra virus to the IGST Act. So these are the major first contention of the taxpayer. Second key contention, or the key contention of the taxpayer, is the double taxation. That means whenever you are importing the goods in India, that is on CIF basis. So on CIF basis, complete custom duty has paid by the importer. The importer custom duty pay kar deta hai, and then he receives the goods. So custom duty levied on the ocean freight also in case of CIF value, and levy of the GST will be lead to double taxation. However, for this, government has argued that there is no double taxation, because whatever the custom duties are levied under the Custom Act, and whatever the GST levied is under the GST, and the credit for the purpose of same is available. However, friends, please note that wherever there is an exempted, or if SSC deals with the exempted goods, then the credit is not cannot be available, and even he can took the refund also. So it becomes the cost. So this scenario has not considered, but major contention of the government is that it is not a double taxation, and even the credit is available. And second, the levy is under IGST Act. Then, in the case of the second double taxation, in the case of the CF contract, the supply of the service of transportation of goods in a vessel is by the foreign shipping line located in a non-taxable territory to an exporter located in the non-taxable territory outside the territory of the India, and its complete transaction is outside the territory of the India, and hence the tax is not liable to be under IGST Act. So these are the key contention. Now we'll see what are the observation and which contention is accepted by the Apex Court. So first, what we say, as per assessee's contention or taxpayer or the respondent contention, that Section 503, under Section 503, government can't specify the importer as a recipient. It can only specify the categories of the goods and services. For this, Apex Court has observed that or whatever decided, the apex court says that the section 503 issued the notification 10 by 2017 specifying the categories of the supply under reverse charge. So it specifies the category of the supply under the reverse charge, and it is valid, and the notification basis also specify the recipient as a who is liable to pay the tax. So under the reverse charge. So it says that the specifying the recipient or importer as a recipient only of clarificatory or the clarificatory nature. So it under this notification they had prescribed the categories of supply only, that is the supply of the service, and the importer as specified as a recipient is only of the clarificatory nature, that importer is the recipient, and hence this notification is not beyond, you can say it's in tune with the GST law, or it not override the IGST Act. So this contention you can say is rejected by the apex court. Second contention what was taken by the assessee is the importer cannot validly termed as a taxpayer person, means जो हमने discuss किया कि importer cannot be recipient, क्योंकि जो भी recipient है that is the export entity and services are provided by the export shipping line itself. So importer cannot be termed as a taxable person. So observation of the court or apex court is that section 503 and section 504 are interlinked section to section 501. Section 5 is the levy, 503 is the levy wherein government can notify the categories of the supply, and section 504 is the government can notify the categories of supply which are liable to under reverse charge. So all these sections are interlinked, and government has observed that since the input notification 10 by 2017 identifies the importer as a recipient liable to reverse charge basis under section 53 of the IGST, the argument of the taxpayer will fail. Again, this argument has failed, or the contention of the taxpayer has failed. So this is again Supreme Court has rejected the argument. Third argument with respect to value, which has been taken, that is that the value is strictly determined under section 15. That means section 15, you are aware about the section 15 gives the transaction value as a value. So as a taxpayer perspective, taxpayer contended that the value should be strictly determined under section 15(1). However, apex court has said that the rule 27 to 31 under the CGST rule prescribe the manner for the valuation. And under Rule 31 also provides the residual power to the GST Council for prescribing the modes of the valuation. So by way of notification 8 by 2017, whatever value, that is the 10% of the CIF value prescribed is correct and it is valid. So again, this contention has been, you can say, that rejected by the apex court, and apex court observations are different. So the whatever the case in favor of the taxpayer, the accepted contention is with respect to composite supply or the double taxation. So apex court, so last contention of the taxpayer was it lead to double taxation because in the case of CIF value, the value or the freight is already included in case of importer of the goods, and the composite, it amounts to composite supply. So Supreme Court observed that the under section 230, in case of composite of supply, so it's a composite supply, so tax should be levied as a principal supply, and here principal supply is the supply of the goods, and accordingly the whatever the ocean freight has included in the supply of the goods, and IGST is already discharged on the same during the custom duty, and hence GST and the ocean freight is not levied. So we had discussed almost 3-4 arguments which are taken by the taxpayer, but only one argument on which basis the case is decided, that is the you can say composite supply and the double taxation, or one transaction cannot not be levied on the double taxation. So this is the brief about case. One of the key observation of the Supreme Court, you can say, that is very relevant is that the apex court says that the recommendation of the GST Council are not binding on the union and state. So the opposite party or the union of government had said that the levy is recommended or the levy is binding because it is recommended by the GST Council. So here the apex courts has observed that the GST Council can give the recommendation. So whatever the power of GST Council as recommendatory in nature and not the binding in nature. So it's not binding on the state as well as central. Now, friends, in long term, this can be used, or this can be that the GST Council can give the recommendation and in state can intend to oppose that recommendation. State has a power to oppose as per the apex court. So this could, in days to come, this could affect the decisions of the GST Council. On the very next day of the apex court decision, the council has given an clarification that it's binding, but even this apex court said that it's not binding and definitely it could affect the GST Council decision in going forward. So the government has given a decision that the notification did not specify the taxable person or difference and recipient under 5U3, and hence under 5U4 or the input levy of the services aspects of the transaction is violation of the principle of the composite supply, and hence the Indian importer is liable to pay the IGST on the composite supply as a supply of the goods as a custom duty in the CIF value and not liable to pay the RCM again on the ocean freight. So this is the decision by the apex court. Now, we had discussed decision, we had discussed the case, we had also discussed the fact. Now, what are the key highlights? So, friends, there could be the first question that what about the GST already paid? तो जो GST already paid हुआ है उसका क्या होगा? तो first scenario हो सकता है कि you had paid the GST and availed the credit and also utilized it credit. अगर आपने GST ओशियन फ्रेट पे भरा है RCM में, आपने वो क्रेडिट भी ले लिया और यूटिलाइज भी कर लिया, then in our view remain that as you had utilized that credit, then whatever the wrong decision by the government should not affect the taxpayer. This is the interpretation, or one can say that that cannot affect the taxpayer, and hence whatever the paid by utilizing the ocean freight is correct, and GST Council could come for the clarification in nature that it is applicable. So don't do anything in such a cases, keep it as it is. सेकंड सिनेरियो ऐसे हो सकता है कि आपने क्रेडिट ले लिया बट वो अवेल नहीं किया, दैट क्रेडिट इज not utilized, it's only availed. For that credit or related to exempted goods also, you had paid the ocean under RCM GST on ocean freight, then there is you can explore for the refund. Again, for the refund, you are aware about that there is a 2-year time limit. So if for the 2 years, more than 2 years already happened, then we recommend that you can file the refund, but definitely there should be the litigation. Because definitely GST authorities will say that the 2 years has already lapsed and hence refund is not allowed. But this levy is itself is not or incorrect, and hence it has to be litigated. Or straight away you can file the writ at the High Court for the purpose of the refund. So we had discussed 2 scenarios where you can utilize and where you had not utilized the credit. Now, third scenario, FOB value. So what if on the basis of whether IGST is payable under the RCM if it is on FOB value. So friends, whatever the decision is with respect to CIF value, and it is completely depend on the decision is completely based on the composite supply and double taxation, and hence we recommend that the in case of FOB value, the GST should be paid under RCM if credit is available, because it is required to be tested again separately in the court of the law for the test of the composite supply in case of the FOB value. So these are the key highlights.